Hello friends, this is Tani Jaiswal and today I have a very relevant topic to discuss with all of you. We all know that a listed company has to look after several things. It is burdened with several compliance requirements like constitution of committees, appointment of IDs, setting up of a vigil mechanism and a lot more. So we know that list is very long. So being a listed company is not an easy task. So friends, from where do we say or how can we say that your company is a listed company? Please note that the definition of a listed company comes from section 2 by 52 of the Companies Act 2013. Now, this particular presentation is being made to discuss on the amendment that has come in the definition of a listed company and pursuant to which several classes of companies now fall outside the purview of a listed company. So as we move forward, let us start with what is the definition of a listed company provided under section 2 by 52. A listed company means a company which has listed any of its securities on any recognized stock exchange. Before the change came, the definition was till here, and that is why it was of concern to many companies, because companies like private companies or companies which have not listed their equity shares were also falling under the purview of being a listed company and were made to comply with requirements which actually was not called for. So the Company Law Committee in its report in the year 2016 as well as in the year 2019 have widely discussed on this particular fact of there requires to be a change, there needs to be a change in the particular definition of a listed company. Now, what is the change? A proviso has been inserted in the definition of a listed company. By virtue of this proviso, certain classes of companies which have listed certain classes of their securities have now been casted under a negative list. When did this change came? Now, this proviso was inserted by the Companies Amendment Act 2020 and was brought into force with effect from 22nd of January 2021. Pursuant to this insertion of the proviso, MCA on 19th of February 2021 has brought or has inserted Rule 2A in the company specification of definition rules and has casted or has brought a negative list of companies which will not be considered as a listed company. As we move forward, we can discuss on which are those companies which will not be considered as a listed company pursuant to this amendment. Now, when we look at this particular chart, what we can see is listed entities is a broader term. It comprises of companies or others. When we say others, we actually mean banks, corporations, SPVs, etc. Now, our focus of discussion is on companies. So coming on the companies part, let us divide the companies into public companies and private companies. Talking about public companies, let us bifurcate it in terms of the listing of the securities which has been done. So a public company which has listed its equity shares which have been publicly offered will continue to be regarded as a listed company. Coming to the next set of public companies which have listed their preference shares. Now, companies or public companies which have listed their preference shares on a publicly offered basis will again continue to be classified as a listed company. Whereas a public company which has listed its preference shares and which have been privately placed. So a public company which has listed its preference shares issued on a private placement basis will fall outside the purview of being a listed company. Now moving to the third set, a public company which has issued debt securities and has listed the debt securities and which have been offered on a public basis. So basically, a public offer of debt securities by a public company will be taken or will be considered as a listed company. Whereas a public company which has listed its debt securities issued on a private placement basis will be excluded from the definition of a listed company pursuant to this change. So this is all about public companies. Coming to private companies which have listed its debt securities issued on a private placement basis have been excluded from the definition of a listed company. So when we look at the exclusion list, it looks like this. So we discussed public companies which have listed its NCDs issued on a private placement basis in terms of the SEBI issue and listing of debt securities regulation. Next, public companies which have listed its non-convertible redeemable preference shares issued on a private placement basis in terms of the SEBI issue and listing of non-convertible redeemable preference share regulations. Public companies which have listed both their NCDs and NCRPS issued on a private placement basis in terms of the SEBI regulations. Private companies which have listed their NCDs in terms of the SEBI ILDS regulations, and public companies which have their equity shares exclusively listed in foreign jurisdictions under Section 23(3) of the Companies Act have been excluded from the definition of a listed company. So friends, with this amendment, what do we think? I mean, this particular amendment is relevant. Why do we say that? Because when we look at the statistics, when we look at the numbers of, how many debt listed companies do we have? When we look at BSP, this slide will tell you most of the companies that are debt listed are actually private companies. So private companies, because they have listed their debt securities issued on a private placement basis, due to this, a definition of listed company, were considered or regarded as a listed company and were required to comply with several requirements of law under the Companies Act. So what are the compliance requirements? We are saying there are a lot of compliance requirements for listed companies. So friends, here is a list of some of the compliance requirements for listed companies under the Companies Act 2013. Provisions which are applicable to all listed companies, like a listed company is exempted from the creation of DRR, then is also exempted from the creation of DRF. Now these are the exemptions. Now talking about what they are required to do, they have to get their annual return certified from a PCS. They have to keep the records in electronic form. Investigation by NAFRA provisions are applicable on listed company. Appointment of a women director, small shareholder director, vigil mechanism. Then there are provisions which are applicable only to listed public companies. What are those? Like reporting on the AGM, which is filing of MGT 15, appointment of IDs, constitution of certain committees like audit and the NRC. So these are the requirements under the Companies Act which are applicable on listed companies or listed public companies. Coming to the second part, under the listing regulations, SEBI listing regulations, the corporate governance requirements will still be applicable on companies which have listed their debt securities or their preference shares. So they are not excluded or they are not exempted from complying with their respective SEBI regulations if they fall under that particular definition. Friends, it is very important to clarify that currently, prior to this amendment in the definition of a listed company, it was very, very clear that the SEBI PIT regulations were applicable on a company which has listed its securities. So whether a company has listed its equity or debt, SEBI PIT regulations were always applicable. So PIT regulations do not define the term listed company. So one has to refer to the definition given under the Companies Act. Now, considering this change, a company which has only listed its debt or the preference shares pursuant to a private placement, will they be ousted from the purview of PIT regulations? In our view, That should not be the case. However, SEBI should consider furnishing a clarification in this regard. Why do we say that? We say that, friends, because the whole crux of complying with PIT regulations lie with the fact that the prices of the listed securities may be fluctuated due to the presence of an OPC or sharing of an OPC. So if a security is listed, its price is subject to change and be impacted by the price sensitive information. Is there any downside of this change that has come? Answer again is yes. For some particular points, you can say there is a downside. What is that? When we look at the provisions of Rule 9A of the Prospectus and Allotment of Share Rules, we find that particularly unlisted public companies are required to get their shares, to get their securities dematerialized. Considering that this particular rule is applicable on unlisted public companies, so now companies which have now been ousted from the purview of a listed company, for example, a public company which has listed its preference shares, they will now be required to, because now they fall under the purview of an unlisted company. So they will be required to follow or comply with Rule 9A, right? Similarly, when we talk about creation of DRR and DRF exemption is applicable to listed companies in case of private. Now, NBFCs will continue to enjoy the exemption even in case they are unlisted, because there's a specific exemption for an NBFC. But pursuant to this amendment, a non-NBFC which has listed its NCDs, will they be eligible to avail the benefit of the said exemption, and will they be required to maintain DRR and DRF? When we look at the rules, the answer may be yes, they will be required. But when we see the intent, right? If the security for which this particular DRR DRF is being, required, if that is listed, then this exemption should also be applicable in case of a non-NBFC which has listed its NCDs. So these were certain points pursuant to which I thought this topic is relevant for the viewers, and I'll be very happy and glad to receive feedback. And if there is any question, please do post so that we can also enhance our knowledge. Thank you so much.